I'm Amanda Sellers.
And I'm Jenna Finkelstein.
And we are the attorneys of Powers, Sellers, and Finkelstein.
Welcome to our ongoing series of informational videos where we discuss Florida statutes and your rights under the law.
DUI Basics. Florida has passed much tougher DUI laws in the last several decades. The interpretation of the laws regarding driving while intoxicated or impaired have become difficult. In Florida, it is illegal to operate a motor vehicle of any kind with a blood alcohol content of 0.08 or greater. Under the law, you are presumed to be impaired if you are over the legal limit. However, this presumption may be rebutted by other evidence presented on the defendant's behalf. The Florida definition of DUI under the statute makes it illegal for a motorist to operate a motor vehicle if the person is under the influence of alcoholic beverages, certain chemical substances, or any controlled substance when affected to the extent that the person's normal facilities are impaired. The consequences of a DUI charge. The consequences of a DUI conviction are often far-reaching and life-altering. This can include incarceration and loss of freedom, loss of employment opportunities, loss of driving privileges, and increased insurance rates. Other devastating elements of a conviction can be a loss or modification of child custody and visitation rights with minor children, significant legal costs, fines and penalties, and a permanent conviction record that cannot be expunged. First-time Florida offenders can spend up to 6 months in jail and face fines of up to $1,000. Offenders can also expect to be ordered to perform community service work and attend alcohol treatment and counseling at their own expense. The penalties and costs of a DUI continue to increase significantly with additional convictions. What to do if you are stopped for a possible DUI? Implied consent law eliminates the need for a warrant to request that you take a breathalyzer test when you are stopped by law enforcement. You will be advised that if you refuse, you will receive an automatic 1-year suspension of your driving privileges if it is your first offense. A subsequent refusal is a separate misdemeanor offense in the state of Florida. If you are under the age of 21 and are arrested for a DUI, your case falls under the zero tolerance policy. All of the penalties are basically the same, but the blood alcohol content presumption is 0.02, much lower than the 0.08 required for offenders over the age of 21. A DUI charge must be taken very seriously, given all of the potential consequences. You may have a defense. Some areas to explore for your defense are: initial stop. Did the officer have a legal right to stop you? Was the stop performed properly? Tests. Were the field sobriety test administered correctly? Did the officer interpret them correctly? Evidence. Was the breathalyzer machine calibrated correctly? Was any other evidence handled improperly or incorrectly? If you or someone you know has been charged with a DUI, or if you would like to learn more about your rights under the law, contact Powers, Sellers, and Finkelstein at 727-531-2926 or visit keepcalmcallus.com for more information and a free consultation.
Thank you for your interest in our informational video series.
If you or someone you know is arrested or accused of a crime,
call us or visit keepcalmcallus.com for immediate representation.
And be sure to text ARRESTED to 63975 and add us to your phone's home screen.
We'll be just a tap away when you need us most.